Thank you very much, Honorable President Saunders. Caribbean Court of Justice, Appellate Jurisdiction on appeal from the Court of Appeal of Belize. Hearing of appeal in CCJ Civil Appeal BZCV number 1 of 2020 between Speednet Communications Limited and the Public Utilities Commission. Today's panel comprised their honors, Mr. Justice Saunders, President and Presiding Judge.
Good morning, Counsel.
Mr. Justice Witt.
Good morning, Counsel.
Madam Justice Rajnat Lee.
Good morning, Counsel.
Mr. Justice Burgess.
Good morning, Counsel.
And Mr. Justice Jamada.
Good morning, Counsel.
May we have the appearances, please? Thank you.
Good morning, Your Honors. Eamon Courtney, appearing for Speednet Communications Limited. With me is Ms. Priscilla Banner. Appearing for the Public Utilities Commission are my learned friends, Senior Counsel, Mr. Fred Lumore. He is leading Ms. Sheena Pitts.
Yes, thank you, Mr. Courtney. Are you ready to begin?
Yes, Your Honor.
Yes.
If Your Honors may
Yes,
hear
Mr.
me
Lumore.
briefly before Mr. Courtney.
Yes, Mr. Lumore.
Your Honors, I want to take this opportunity again to render unreserved apology for the aborted hearing, which was scheduled, I think, on the 30th of July, the last time. I sincerely apologize for making it impossible for the matter to be heard on that day.
Yes, Mr. Lumore, you put that behind us. That's fine, but we accept that. Appreciate your
and
apology.
if Your Honors can hear me in respect of housekeeping, in respect of page 2 of the Notice of Appeal,
Yes.
which are the grounds. In respect of grounds 1A, B.
Have you discussed this with Mr. Courtney?
No, we didn't have the chance to discuss it.
Oh, Mr. Lumore, what are you springing on us and on him now?
Nothing extraordinary.
Yes.
We are both, just to say that both sides are agreed, are in agreement that those grounds should succeed, A, B, and C. There are no contentions about those.
Just a second, I'm trying to find it. What page of the record is it?
Page 2 of the record.
I see.
Mr. Lumore, is that ground 1, A, B, and C you are saying should succeed?
Yes,
So it's ground 1, A, B, and C.
that's right.
I see.
And our cross appeal are also in alignment with the position of the appellants. I will point out those grounds which are also in alignment with the appellant's grounds, which will be our 2A, 2B. Sorry, Your Honors, our cross appeal is at page 454.
Two A, 2B.
2A, 2B, and 2C. Those grounds align with the appellant's grounds A, B, and C, and we are all agreed that those grounds should succeed.
Okay, that's 2A, 2B, and 2C?
Yes.
But I suppose there are still some things you don't agree.
Yes, which will be the grounds in contention are on page 3, which will be the appellant's ground D, E, and F.
Yes. Yes, is that it?
Yeah, that's it, Your Honor.
Yes. Mr. Courtney, is that agreed?
Your Honor, I am hearing this and seeing this for the first time. Nothing strikes me that I ought to quarrel with by what Mr. Lamore has said. I wish, having heard my learned friend, to start by accepting on behalf of Speednet Communications the concessions made by counsel for the Public Utilities Commission. And in that regard, I invite the court's attention to page 454 of the record.
454, you said?
That is correct, Your Honor.
Yes.
My learned friend indicated to the court that grounds 2A, B, and C of his cross appeal, quote, align with the grounds he conceded in the appellant's cross appeal. Your Honors, it is now common ground in light of that concession that the Court of Appeal did not, I put it in a negative, did not err when it decided, and at the very bottom of page 454, that the PUC allowed the appellant to do a test run on its equipment so as not to delay the application process. My learned friend has said that he accepts our position, which is that in fact, as the trial judge found, what happened was that a test run was permitted by the PUC. Your Honors, that, in my respectful submission, is a very important change of position by the PUC, and I will develop that in my argument. The court will appreciate, Your Honors, that this appeal traverses a very narrow compass. In outline, what occurred is as follows. In 2011, Speednet applied to the Public Utilities Commission for the use of a portion of the 700 megahertz band. The court will be aware that the radio frequency spectrum is divided into bands by the Public Utilities Commission, which publishes a spectrum allocation plan. In 2011, the 700 megahertz band was assigned to broadcasting and not to mobile services. The Public Utilities Commission informed Speednet that it was not in a position to approve that application. Your Honors, could I invite the court's attention to page 161 of the record. Can I proceed, Your Honors?
Yes.
That is an exhibit to the affidavit of Mr. Justin Barrow, the witness for the commission. He exhibits a letter addressed to Speednet in answer to the request for the allocation, and he says, as you may be aware, the 700 megahertz band, specifically 698 to 806 megahertz, is assigned to broadcasting TV channels 52 to 69. Therefore, at this time, the Public Utilities Commission cannot authorize the application for services requested. However, the PUC is in the process of reviewing Statutory Instrument number 110 of 2002 and the current spectrum allocation plan with a view to making available some parts of the band for other services such as mobile services. At that time, we will be in a position to entertain requests for application for assignment in this band with technologies recently developed. Your Honors, could I invite you to page 157, which is the body of Mr. Barrow's affidavit. At paragraph 8, Mr. Barrow's sworn evidence is as follows. Sometime on or about 29 September 2011, the claimant, Speednet, applied to the PUC for a license to use a portion of the 700 megahertz band for mobile phone services. At the time, the PUC was in the process of changing its radio frequency spectrum because of regional and international commitments to the International Telecommunications Union and its radio regulations. As such, the PUC could not grant the license sought by the claimant. I respectfully submit, Your Honors, that the letter which I referred to and this sworn evidence from the Commission is incontrovertible evidence from the Commission that at the time of the application, the Commission could not approve a license. It could not approve an allocation of the bands to Speednet. This is the evidence of the Commission. We accept this evidence. We do not dispute this evidence. It is not contradicted by any evidence. Your Honors, without going...
That's Mr. Courtney, sorry, that's in 2013, right?
Yes, 2011 was
2011.
No, this letter from Mr. Barrow that you read. What's the date of that letter?
I was about to say, Your Honor, the important point to which Justice Jamadar is highlighting is that this sworn affidavit from Mr. Barrow is dated the 2nd June 2017.
2nd of June 2017.
Yes, Your Honor. So
the amendment was done in 2018, I believe, right?
6th of October 2018.
And when was the letter written, the date of the letter?
The letter that Mr. Barrow refers to is dated the 21st of November 2011.
All right.
So as late as 2017, this was the position of the Commission in sworn evidence to the court. Your Honors, Speednet followed up, and I don't intend to turn up the letters, with the Commission with respect to being able to use the 700 megahertz band. What the court will see is a letter from Speednet to the PUC, which can be found at page 162 of the record.
Mr. Courtney, may I interrupt you one more time? Sorry. Up to 2017, was there, sorry, up to 20, yes, I think 2017, were there any demands made, or when was the first demand made for fees?
Your Honor, that was on the 21st of February, 2017.
Right, 21st of February 2017 is the first demand, right?
That's correct, Your Honor.
Yeah, thank you.
Your Honor, I was saying to the court that on the 6th of May, 2013, page 162 of the record, Speednet writes to the commission, chasing it and saying, in 2011, we applied for a license. We have not received it. And if I can just quickly read the two last paragraphs on page 163. This is Speednet writing to the PUC. Please note, it is now 1 year and 7 months since Speednet applied for the 700 megahertz spectrum. The PUC's long drawn out and apparent hesitancy to approve the application in a timely way has put Speednet at a competitive disadvantage and is a disservice to customers. Any further delays will cause greater economic harm to Speednet, hindering the expansion of its enhanced data services to customers and the Belizean public. If it is the case that the Commission will be further delayed in approving the entire National Frequency Plan, we hereby request that the Commission releases the appropriate 700 megahertz spectrum now for a field trial by Speednet in Belize City and Ladyville within the next 3 months, leading to full deployment countrywide thereafter. Attached, please find a spectrum scan of the 700 megahertz in Belize City showing that the band is clear of interference and is available for immediate use. It is the fact, Your Honors, that Speednet in this letter is saying, you haven't done the reallocation, please allow us to do a test. The response, Your Honors.
No, don't go so fast, Mr. Courtney. I want to understand something.
Yes, sir.
So even though the letter said you can do a test, is it that the 2013 letter from PUC, correct? Is it then that up to the writing of this letter that you have just referred us to at page 163, in fact, no 700 bandwidth was available even for testing? Is that what the letter is saying?
Yeah.
Or is it asking for more bandwidth?
No, my understanding from this letter and what the test showed, as I understand it, is that the 700 megahertz spectrum, that portion that they did the test, as to quote the letter, showing that the band is clear of interference and is available for immediate use. So within that band, there may have been some portions of the band assigned to broadcasting radio, but not all of the 700 bands. And what Speednet had done was tested some bands to show these bands are not being used by any other service. So if you reassign them, we can use them. So that was 2013.
So that is evidence that up to here, all they were doing was testing.
That is correct, yeah.
All right.
We then go to page 168.
Sorry, Mr. Courtney, if I may.
Yes, John.
This letter to which you refer, page 162, wasn't this a letter written in response to the PUC sending the consultant's report for the comments from Speednet?
Your Honor, can I answer that by inviting the court to look at the evidence? The second affidavit of Mr. Torres, which begins on page 153. At paragraph 3 of Mr. Torres's affidavit, he corrects the PUC. He says, in reply to paragraphs 8 and 9, an application was indeed made on the 29th September 2011 to the PUC for a license to use a portion of the 700 megahertz band for mobile phone services. According to the statements previously made by the PUC, its reasons for provisional assignment of band 13 was to allow it to assign portions of the 700 megahertz band to mobile services and not due to commitments to the ITU, as the PUC states. It is within the purview of the PUC to make this change. He goes on, Your Honors, to point out that, in fact, when you look at paragraph 7, same affidavit, page 154, the consultation with the PUC was in 2015, not 2013.
if you look at how do you explain paragraph 2 of the same letter to which you've just cited paragraphs, the penultimate and ultimate paragraph, well, penultimate and for all practical purposes, penultimate and ultimate paragraph. But what about paragraph, this is the letter of 6 May 2013. What about paragraph 2 of that letter? What does that mean?
Your Honor, this is referring to a consultation with Speednet that was being done by some consultants.
Was it done by PUC's consultants? Or
Yes, yes, Your Honor.
That's what I thought, and I thought that PUC had sent their consultants' report to Speednet and to Telemedia for their comments.
Yes, Your Honor.
So, in light of that, I'm at a loss as to, perhaps that's putting it badly. You could perhaps help me to understand what you are saying about the 2 paragraphs that you read at the end of that letter.
The only point I was seeking to establish was a chronology, Your Honor, to say that in this letter of the 6 May 2013, Speednet was complaining about the failure of the PUC to do the assignment, and secondly, to ask for permission to do testing if it was going to be continued delay in the reallocation of the frequency. What Mr. Torres says, and I take it, I leave it there, is that it is within the purview of the PUC to make the change as it ultimately did in 2018. Your Honors, I was taking the court then to the response, which is to be found at page 168. And this is the critical letter, Your Honors. It's dated the 29th of July 2013, and the Commission writes back to Speednet and says, we write in response to your application for frequency authorization made on the 29th of September 2011 and your various correspondences. And I pause there to say that the various correspondences are in the file, and it refers to letters from Speednet chasing, asking for when is this going to be formalized. Please be advised that the Public Utilities Commission hereby grants frequency authorization to Speednet Limited for the use of the following radio frequency bands as stated in your application. The uplink and the downlink are set out. The granting of the authorization to use these bands is provisional at this time, so as not to unduly delay the deployment of your intended services, but to become formal upon the publication in the National Gazette of an amended spectrum allocation plan that reassigns a relevant portion of the 700 megahertz for mobile services as opposed to broadcasting, which the PUC has already initiated and is expected in a relatively short course. Upon such publication, you are expected to immediately pay the required first year fee of $4,000. The annual fee is calculated at $366.67. The end of the first year fee is therefore calculated at $361,666.67 and will be due on the anniversary of the publication of the National Gazette of the amended spectrum allocation plan. The annual fee will be due thereafter on subsequent anniversaries. Overleaf, the PUC is granted this authorization in response to your original application, therefore no further application or payment of the application is required. What had happened, Your Honor, is that Speednet, because of the delay, applied again after they issued a second application and paid again the application fee, which was returned. And then settled thereafter, Your Honors, are certain things that have nothing to do with this case, save and except, as we've said in our written submission, that these matters are evidence in our respectful submission that this letter did not constitute the license that was required by law. Your Honor, can I very quickly go back to page 127?
Mr. Courtney, to be clear, this letter is clearly a reaction, a response to the original application from 2011. It is not a reaction on the letter of the 6th of May 2013, correct?
That is not my submission, Your Honor.
But the letter says this
Yes.
is in response to your original application, and the letter starts also, we write in response to your application for frequency authorization made September 29, 2011. So it doesn't refer to that letter of the 6th of May at all.
With respect, Your Honor, it says, and your various correspondences in regards to the said subject matter, which includes that very letter. And
Yeah.
I make the point, Your Honor, that when you come to the third paragraph, it says the granting of authorization to use these funds is provisional at this time so as not to unduly delay the deployment of your intended services. That is specifically going back to the complaint that Speednet had made in the letter of May, saying you are unduly delaying me and you're prejudicing me. This
Yes.
was...
And in that letter, you Speednet was asking for, give us some time to do some testing, correct?
Yes, Your Honor.
For a few months.
Yes, Your Honor.
But having read the files, Speednet did much more than just testing.
That is correct, Your Honor.
Okay, so, but we will probably get to that point.
Yes.
But
Okay.
Mr. Courtney, you said that this letter did not constitute a license.
Yes, Your Honor.
So under what authority subsequent to this letter was Speednet using the particular frequency?
Your Honor, we will respectfully submit that it was doing so without formal permission from the Commission. This is the only letter that can be referred to by both sides.
So it was operating outside the law?
Yes,
Because
Your
it
Honor.
didn't have a license?
Yes, Your Honor. And the intention was, as I read the communication from the Commission, we will allow you to do this for a short while because we intend to reallocate the 700 band, and then it will quote unquote formalize the situation. So,
Mr. Courtney, if I may.
yes, sir.
Yeah, just to follow up on the President's question to you. Is there a definition or form, a statutory form or a statutory format which has to be used to have a license, to evidence the presence of a license, quote unquote? Does the act require any formalities?
Well, the Act does not, nor the regulations do not prescribe a form of license. The Act and the regulation does require formalities to be in the license.
It does.
Formalities for what? I'm sorry, I didn't get that last part.
Yes. What I'm saying in answer to Justice Burgess is, one, as far as I'm aware, there is no form of license promulgated by the Commission. What the Act provides is that there are certain conditions, terms and conditions, which must be included in the license, and it can be done in two ways. One, it either sets them out in detail in the license itself, or two, it says specifically in the license which provisions in the Act and the regulations apply to that licensee. If I could turn that up, Your Honor.
I didn't hear the last thing, your last comment, Mr. Courtney.
Yes, Your Honor. I was saying that my understanding of the Act is that you can do terms and conditions in the license in two ways. One, setting them out in detail in a license, or two, saying by whatever instrument you issue, which provisions of the Act and the regulations are incorporated by reference into the license.
Yes.
And if I could turn that up, Your Honor.
But shouldn't we, is there any indication that you shouldn't give the word license its normal, natural meaning, which is basically an authorization to use?
Your Honor, I would not give it any other meaning than that. And to use the language of the court, the authorization given by this quote-unquote license, which we do dispute, is set out in the third paragraph, so that it would say, to use the word license, the granting of this license to use these banks is provisional, so as not to unduly delay the deployment of your intended services. It will become formal, therefore it is informal, upon the publication in the National Gazette of an amended spectrum allocation plan that reassigns a relevant portion of the 700 megahertz band.
But Mr. Courtney, I don't want to interrupt you, but isn't that a very narrow approach to the matter? You are accepting the adjective formal before license when this is not used in the statute, but you are disavowing the possibility of a provisional, which is also an adjective before license. What is the statutory indication? How does one arrive at that position using the accepted tenets or canons of interpretation, statutory interpretation?
Your Honor, it is common ground between the Commission and Speednet that the Commission does not have the power to issue a provisional license. That is common ground between us. The law.
Yes. Sorry. Yes, that's common ground between you. But I dare say that because the ground is common doesn't necessarily mean that it represents the law. And that is what I think we have to be convinced of.
Your Honor, I would say emphatically, there is no provision in the statute that authorizes, or the regulations that authorizes, the grant of a provisional license. There is none. And I would respectfully submit that Section 6.1 of the Belize Telecommunications Act confines the powers of the Commission to the provisions in law, the powers conferred on it by the Act and the regulations, and it is not authorized or empowered to issue a provisional license. Your Honors, if I can turn up Section 15 of the Act, which is to be found.
Courtney, wait a minute. So are you therefore saying that you accept that what was happening was an unlawful activity under the activity that was unlawful under the Act? You can't have it both ways.
I'm not having it both ways, Your Honor. We specifically submit to the court. We use the colloquial language in our submissions that, in effect, what the PUC was doing was giving Speednet apply, saying, listen.
Well, all right, but let's not use the colloquial language. Let's use proper legal language.
Yes.
You may have somebody using drugs and the police may not charge them. You give them a bly. But is the use of drugs lawful or unlawful? Your propositions lead to a conclusion, it appears, that on your argument, since there was no power to give a provisional license or an informal license or an interim license, whatever you want to call it, therefore it was an illegal activity. Whether both of you were engaged in it or not, was it an illegal activity? Let me not say illegal. Was it an unlawful activity that both Speednet and the PUC were engaging in the context of the, is it the BTA? Yes.
Yes, sir.
What's your candid response to that?
My candid response to the court, as it appears in our written submission, is that from 2013 until now, there is no license issued to Speednet to use the 700 megahertz band for telecommunication services. It follows in our respectful submission that Speednet is operating unlawfully with the turning of a blind eye by the PUC. I say, Your Honor.
And so wait a minute. So is Speednet doing this for profit? Is Speednet engaged in a profitable enterprise? Is it doing this for profit?
Yes, sir.
So Speednet is engaged in an unlawful activity for profit. And the proceeds of that unlawful activity, the profit, is benefiting who right now?
Well, I don't know the financials of Speednet, but assuming the profit is being made, I would assume dividends are being distributed to
shareholders of whoever Speednet shareholders are.
Yeah, I assume that would be the consequent, the logical result. Assuming it's making money, I don't know. But Your Honors, can I just underscore?
So, no. Before you go on, just indulge, I think, both Justice Burgess and myself a little bit. Just hypothetically, if in fact, under Section 6, they could have granted a provisional or an informal license, and if on a purposive construction of the legislation that is within the terms of setting up an organization to try and achieve what they were trying to achieve. So let's just start on the premise for now. I know you don't accept it, that what was in existence from 2013 at least was, to use your language, an informal license. I think that much you are willing to say. What would be the consequence in law of that occurrence on the document, on the July 2013 letter? Because what we're playing here is with words. Provisional authorization, we have now translated to mean provisional or informal license, assuming that we conclude they could have done that under Section 6 or however else we construe the legislation. What would be the consequences?
Your Honor, as I understand the question, we are assuming that the legislation, Section 6, authorized some sort of temporary, some sort of informal approval, and that the letter of the 29th of July 2013 was that informal approval. What is the consequence? The consequence on those assumptions is that Speednet would be operating lawfully on the basis of Section 6.1 as interpreted in that way, and the letter of the 29th of July 2013.
Good. What would be, if any, the fee consequences? Because that letter also says that, look, fees will become due upon a certain eventuality, which the letter also says is going to happen in a timely fashion. So that everybody knew that, look, this annual fee calculation is all set out in great detail there. Both parties, when Speednet received that letter, both parties expected that within a timely, within a short time, I think the language is, in a timely fashion, these fees are going to become due. So my second part of this little question is, given that it was operating lawfully now under provisional license, what would be the fee consequences based on the letter of July?
Yes, sir. Based on the letter of July, we will have to delete everything after. Well, on page 127, we will have to delete the last two paragraphs, because the law requires, on the analysis just put forward by the court. On the court's analysis, assuming 6.1 would apply, assuming that this were a provisional license, we would have to find a provision in the law that would empower the PUC to charge a fee for provisional licensing. There is no such provision. That is why the commission wrote the letter in the way it did and said, once I do the reallocation and I formalize the situation, I bring myself within Regulation 8 that says you can now charge a license, and within Section 15 of the Act that says when you issue a license, make sure that you collect the fees.
So therefore, on that analysis, on the, is it October 2018? I forget the date now.
6 October 2018.
When the amendment was, when the amendment occurred, is it then that based on this letter, because it says will be due on the anniversary of the publication in the Gazette of the amended SAP?
Right. Your Honor,
is it then that we know as a question of fact that I think it's October, that in October 2018, the SAP was amended and published? Is it then that that is when the fee would have been due on this contract?
I wouldn't call it a contract, Your Honor, but not to quibble over words, I understand the court's question. The answer is, it is my respectful submission that on the 6th of October 2018, one would have expected that the commission would have written to Speednet and said, we have amended the SAP, here is your license, sorry, the fees are now payable, and set out the fees. And that has not happened.
But that's a formality. The agreement says that it will be due on the publication. If we know it was published, why would it not be due on the event of the fact of the amendment? Why not?
Your Honor, I repeat. 1, on the 6th of October 2018, it is my respectful submission that the Public Utilities Commission would have been in a position to make the demand for the fee. This case does not refer to license fees for 2018 going forward. It does not.
No, forget about this case for now. What
Yes.
where I think we've reached is that on the two assumptions, I know you don't accept them, and they were started by our brother Justice Burgess. On those two assumptions, as of the 6th of October 2018, Speednet is accountable. You would say on those assumptions, Speednet would be accountable for the fees due going forward every year after.
If formally, lawfully demanded, yes, Your Honor. And Your Honor, can I just say,
Yes.
at trial and in the Court of Appeal, and I repeat here in my written submissions and now to the court very formally, Speednet accepts that it must pay for the use of a 700 megahertz band as long as it is licensed and the demand is made.
Are you willing to pay from the 6th of October? Let's be very pragmatic. Are you willing to offer Mr. Lumor and his client to say, look, we are willing now in 2020, albeit, to pay from the 6th of October as per this and move on? Are you willing to say that? Mr. Lumor may say, I'll accept it. We have a short hearing, Mr. Courtney.
Accept money anytime.
I'm very serious, Mr. Courtney, actually.
Your Honor, unsurprisingly, I have not received any such proposal from Mr. Lumor, first of all. Secondly, and it is important that I say this, that we have repeatedly said that Speednet will pay what is lawfully due. I have to accept, as I have indicated to this court, that come the 6th of October 2018, the spectrum allocation plan was amended. I have indicated to my client, well, let me put it differently. If a demand was made by the Commission for spectrum fees from October 2018 going forward, it would be difficult for me to advise Speednet that it is not liable to pay those fees. I have no specific instructions, Your Honor, Justice Jamadar, and so I cannot say to you that my client would accept it. But the best I can say is it will be difficult for me to advise Speednet that the plan having been amended, it is not liable. I would say one thing would be required, Your Honor, is a license. It is important, Your Honor, for me to say to the court that this letter of the 29th of July 2013 cannot be the basis on which the Commission says the fees are now due. The fees will become due, one, by the regulation and the amended spectrum plan. And then Speednet would need a license, as it does for its mobile services. It would need a license that sets out all the terms and conditions for renewal, the duration, dispute resolution, etc., as required. It couldn't take this letter to its bankers, to regulators, and say, I am licensed, here is my license. I say that, Your Honor, to say we would be constrained by, not so much by this letter, but by the amendment to the plan, which then authorizes the formal allocation to Speednet of the 700 megahertz band. With a license, we would be constrained to say to Speednet, no, you can dispute paying those fees. I have no instructions to say my client would pay and accept my advice, but I think the court understands what I'm saying.
I do, and I appreciate your candor. Maybe Mr. Lumo will talk to us about that when the president invites that, maybe at an opportune time. I don't want to take up more of your time, Mr. Courtney. I appreciate your candor, as always. Thank you.
I just want to, Mr. Courtney, detain you a little longer, just to understand what is Speednet's position in this case. I gather that Speednet is saying that it did not have any license in 2013, and it does not currently have any license, and it is therefore ineligible. It doesn't have any obligation to pay any license fees, that it is operating unlawfully, and the fact of that unlawful operation does not oblige it to pay any fees. But that unlawful operation is being winked at or is ignored by the PUC, and that state of affairs can and should continue until either the PUC puts an end to it, or the police comes in and say you're operating illegally, or the PUC gives you a license. Is that a fair assessment of your position?
Your Honor, I would say that it fairly represents, I will condescend to more details, but I think it's a fair assessment. And Your Honor, the point of the matter is this. Two things. First of all, when this case began, there was no allocation, no amended spectrum plan. In the Court of Appeal, we wrongly argued on the basis that the spectrum plan had not been amended. I was not aware, nor was Speednet, that the plan had been amended. As we say in our written case, had the Court of Appeal been informed that on the 6th of October 2018, we argued it in March 2019, that the plan had been amended. In my respectful view, the question would then be to me and to my learned friend, well, now that we have an amended plan, counsel, how can you say that you're not going to pay from 2018 forward? And I have already said to the court my position on that. But what we submit, Your Honors, and submit very forcefully, is that prior to that allocation, amendment of the allocation plan, it was not open to the Commission to demand the license fees. And Your Honors, I must underscore this, a point hinted to earlier by the bench. There was no demand by the Commission in 2013, 2014, 2015, 2016. The only thing that happened was this court's judgment in December 2016, in which a court ordered a refund to Speednet from the Commission, that the letter of the 21st February is sent saying, listen, let's set off these two amounts. The point we make, Your Honors, is that even at that stage, the Commission was not concerned with saying, I am now formalizing a situation, I am now issuing your license, here is your license, pay fees from 2018 going forward. That was not the position. It is when we said you can't do this to us that they say, well, guess what? The 2013 letter, that's your license. And because I need a license to be issued to you to charge you fees, I am saying that the 2013 letter is your license. I make one further legal submission, Your Honors. We submit that there is no provision in the Act or the regulations for a provisional license. When the letter of the 29th July 2013 is read in context, it is very clear in our respectful submission that, one, the PUC was delayed. They decided to give another a wink, say, go ahead and test it. We're going to formalize the situation very quickly. They didn't. Speednet continued, Speednet rolled out. Your Honors, in the record are two letters from Speednet after this, chasing and saying, when are you going to formalize this thing? When are you going to formalize the situation? There was no response until the judgment. The legal submission I make is this. If the court is with me that there is no provision for a provisional license, it is my respectful submission that the proper interpretation to be given to the letter of the 29th July 2013 is that an informal permission authorization was given with the intent that once the spectrum allocation plan had been amended, the Commission would, for the first time, exercise its power pursuant to Section 15 and Regulation 7 to say, no, I am now granting you the license. What occurred before that was expected to be a short-term blight, as I put it in my written submission, so that the first time that the formal exercise of the statutory power was supposed to be after the amendment. Now, the amendment took place in 2018. In my respectful submission, the Commission has still not, to this day, having amended the plan, exercised the statutory power and said, here is your license, pay me my fees. I make one final point on this, again, in response to questions from the bench. We ask this court to take a look at the language of the amendment to the spectrum plan. It is a legal document. Your Honor, if I could ask you to turn it up, I'll be very quick on this.
What page?
Page 588. Is the court there?
Just a second. Yes.
I asked the court to take a look very quickly, this is the 6th October 2018 publication in the Gazette. In accordance with Section 12.7 of the Telecommunications Act, notice is hereby given of the adoption with amendment by the Commission of the previously gazetted spectrum allocation plan for Belize, which is to take effect as of the date hereof.
The date is October 2018?
6th October 2018.
Oh, I didn't see the 6.
At the very top, Your Honor.
Ah, okay.
The point I make, Your Honor, is this is a formal order of the Commission pursuant to Section 12.7 that takes effect on the 6th of October 2018. Prior to this, the 700 megahertz band was effective for broadcasting. The Commission could not, in keeping with its obligation to manage, administer, plan, and control the spectrum allocation plan transparently, effectively, and efficiently as required by the law, issue a license to Speednet to use that when it is assigned to something else. It begs the question, how many more of these letters are out there? Your Honors, we say the Commission in this particular case chose the 6th of October 2018. That was their choice. Could they have chosen an earlier date? I leave that there. Your Honor, I want to make one point on the license, the so-called license, and simply to ask the court to take note of Section 13 of the Telecommunications Act, which appears on page 534.
Mr. Courtney, one question. So, knowing all of this, Speednet is still making use of this unlawful license?
Your Honor, well, it can't issue a license to itself.
No. So, but anyway, Speednet is using the frequency bands that were in this letter, correct?
Yes, Your Honor, tens of thousands, I think it's close to 200,000 subscribers are using 4G telecommunication services.
While and Speednet provides this, knowing that, or arguing and knowing that it is actually unlawful.
Your Honor.
Isn't that so?
Your Honor, I repeat, there are letters in this file which shows, as a trial judge concluded, that it was Speednet that repeatedly wrote to the Commission saying regularize the situation.
Mr. Courtney, what our brother is asking you is ground I think we have covered. You may have written, that only makes the point more poignant that you knew you were acting unlawfully, hence the writing and demands to regularize, to formalize, to give us a license.
Yes, Your Honor.
Yeah, okay.
And I don't want to turn up the sections in the Act. I'm sure Mr. Lamore has hinted at them already. There are ways for the Commission to deal with this. If somebody is operating without a license, the Commission needs to act. That's a matter for the Commission.
Mr. Coney, let me tell you what one of the things that concerns me in this case. Now, there is the law. There is an act. There is judicial interpretation of that act. These things are, so to speak, objective.
Yes, Your Honor.
Then there is behavior of the Public Utilities Commission, and then there is a customer, Speednet. Our concern should be to apply the law. If the behavior of the Public Utilities Commission is either not in keeping with the law or is inefficient. If, for example, and this is purely an example, I cast my aspersions on anyone, you have a board that is indolent, inefficient, a CEO that doesn't know what he or she is doing, and they treat with a customer in particular ways that are not in sync with what the law prescribes. Is the customer entitled to say, well, never mind what the law prescribes, these officials have said to me XYZ, which is not in sync with the law, and therefore I am not obliged to follow what the law prescribes? Is a customer entitled to say that?
Absolutely not, Your Honor. But, Mr. President, with respect, I believe, I submit that what you have is and the court is asking me to look at the factual, actually what is happening. And what is happening here, or what has been happening, is a telephone company that was operating third generation systems, hundreds of thousands of customers. It is evolving to 4G, fourth generation, and it is applying to the regulator for permission to make that transition. The regulator says, I can't entertain that now because I need to do an adjustment to the spectrum allocation plan. Speednet continues to follow up and say, listen, you're delaying me, you're in fact prejudicing me against the other competitor. Can you at least allow me to test? The commission says, I will allow you to test. Here is what is going to happen when I make the plan, which I expect to do very shortly. I expect to do this very shortly. So there was no doubt between Speednet and the commission that the commission intended to make the amendment. It could not issue the license without the amendment, and that it intended to make the amendment very shortly. And once that amendment was made, it will formalize the situation. I say issue a license and make the demand for the fees. It never did that for 4 years.
If I may,
so
we have all of that ground. We have all of that ground. Is there anything in the record, and has this issue ever arisen as to when, at what point, what date Speednet moved from testing to rollout? Anything ever turned on that? Is there a date on that? Is there any issue on that?
No, Your Honor. There is no evidence of that.
I see.
And yeah, it never arose. But Your Honor, I just wanted to make the point in answer, because I don't want the impression to be left at all that Speednet is a rogue operator.
No, and I don't think any of us believe that. And we those of us, well, let me speak for myself. When I cast what is being the situation now in the frame of unlawful activity, it is the result of, what exists. I mean, if it isn't lawful, then it is not lawful, but nobody is suggesting that, and we would have questions for Mr. Lumo, Mr. Courtney, have no fear. Nobody is suggesting that Speednet is a rogue operator.
Your Honor, I just wanted, the last point I wanted to make.
Mr. Courtney, before you move on to that, just to go back to that one point, please. At paragraph 32 of the Court of Appeal judgment, I believe there it is said, again, there isn't a date as far as I see, but the writing judge says, in my considered opinion, much of the present case turns on the significant fact that Speednet did not merely test its technology on the 700 megahertz platform and then discontinued its use until such time as the formal license was granted per the 2013 letter. Speednet continued to use the spectrum to great political gain. And according to the judge, the PUC in 2017 realized that the current state of affairs violated the statutory requirement mandating the payment of fees for the use of the particular frequencies and sought to retroactively collect the fees that were due. So it doesn't appear that there is any dispute that testing came to an end and rollout started.
No, Your Honor.
Yes.
The answer was that I don't know when that transition took place. But Your Honor.
And more than that, it's not significant to this case.
Indeed, Your Honor.
Yes, that's the point I wanted to make, because I think that is the point the Court of Appeal was making, that Speednet continued to use the spectrum to great commercial gain. But I do understand what you were saying. Thank you, Mr. Courtney.
Obliged, Your Honor. And Your Honor, just to make clear the point, that and in the next paragraph, the Court of Appeal goes on, I do not consider it just equitable in the face of present circumstances for Speednet. Now, after 6 years of use to assert a provisional license granted is unlawful. The only point I make, Your Honors, which is obvious, judicial review is about legality and not about equity. I make the following point, and my hour has passed, so I'll be very quick. In relation to paragraph 32, to which the court has directed my attention, that last sentence that says the PUC in 2017 realized that the current state of affairs violated the statutory requirement mandating the payment of fees is, with respect, not accurate. When one reads the letter of the 29th of July 2013, the PUC was aware that license fees were to be paid. It chose to defer the payment until it had legalized the situation. So I just wanted to make the point, Your Honor, that it is not accurate that it is 2017 that they realized the situation. What happened, Your Honor? Two final points. One.
Mr. Courtney, can you cover in your final points? Just help me with one little thing. What is the disadvantage to Speednet, or the disadvantage to Speednet not having a license? Earlier on you spoke about, commercial. You can't, if you didn't have a license, you can't go to A, B, and C and raise funds and so on. What prejudice, what disadvantage? You can cover your 2 points and then you can come to this at the end. That's fine with me.
Your Honor, I want to respond to it directly. And the best I can say to you is the following. Far too often, Speednet seeks advice from my firm. For example, in the first Speednet case that came to this court, where it is operating in a situation where the regulator is being arbitrary, where the regulator is not complying with what is required. Speednet is in a competitive environment. It needs certainty and clarity and transparency, and it is nervous because it doesn't know whether what it is doing is accurate, whether it can do it. It gets permission to do something, and then it is told it can't. It attempts to import equipment, and then it's told it can't and has to pay $792,000 to get it in, etc., etc. The prejudice, Your Honor, is the uncertainty of a commercial entity who wants to do business in a transparent way. It is very difficult for it where the regulator is not abiding by the law. Your Honors, the 2 points I wanted to make was section 13 of the Act, and I will just read it. It's on page 534. It says, the PUC shall ensure that adequate publicity is given to any terms and conditions of every license issued under this Act. The side note for that section is transparency. If the letter of the 29th July 2013 is in fact a license, it begs the question, what are the terms and conditions of the license? But secondly, and just as importantly, Section 13A obliges the Commission to make public the terms and conditions of the license. Can the PUC, is it the intention of the PUC to comply with the law and publish this letter? I submit, Your Honors, that the letter is not a license. The final point I make, Your Honors, is this. The amendment to the spectrum allocation plan by the Commission should have been disclosed to the Court of Appeal. Had it been disclosed to the Court of Appeal, the case, and perhaps this case, this appeal, would have turned on the true question. Now that the allocation plan has been amended, what fees are due? Unfortunately, Your Honor, that was not done, and as a result, we are here arguing about fees up to 2016 and not after 2018. And just to be very clear, my junior makes the point, Your Honor, and it's in our speaking note, in our written submissions, Your Honor. Speednet has a license to operate. I just want to make clear that the court is aware. If the court can turn to page 476. Paragraph 30 of our submissions. Speednet is a holder of an individual license issued by the PUC, which enables it to offer mobile services to its customers throughout Belize. Footnote 25 refers to the affidavit, and it says, as a matter of interest, the individual license issued to Speednet by the PUC is 61 pages long. What is before this court is a license for spectrum allocation. So it is a license to offer the services. The question is the license for use of the spectrum. So the point I was making, Your Honor, is that, as I said, it is not a rogue operator, but the true issue that ought to be engaging Speednet and the PUC is what should happen post 6 October 2018 when the plan was amended. Your Honors, I rest on my written submissions as well as the speaking note which we filed, and unless I can be of any further assistance to the court, those would be my submissions. I apologize for exceeding my hour.
Yes, that's okay. All right, thank you.
Much
yes, thank you, Mr. Courtney. Let's take a short break, and then we'll come back at, well, it would be 10:30 in Belize, but 12:30 here in Trinidad and Tobago. So what I invite you to do is to mute your microphone and your video, and at 12:30 we will unmute and resume.
Obliged. they don't.
Mr. Lumore, are you ready for us? You're on mute. Oh, okay.
Sorry.
Your Honor, could I just interrupt?
Yes.
Your Honors, I, in the interim, took instructions from my client with respect to the question raised by the bench. And I can say that I'm now instructed to say that Speednet would comply with page 127 of the record, the letter from the commission. The last paragraph.
Just a second.
That is page 127. That is the demand letter. Oh, this is the license.
It's at 168 too.
That is the letter dated 29th July 2013.
Yes, Mr. Lamar. That is to say, Your Honors, if the court is with me,
Yes.
that once the spectrum allocation plan was published on the 6th of October 2018, Speednet would acknowledge that the first year fee of $4,000 would be payable then, and the annual fee calculated at $366,666.67 will be payable at the end of the first year, which is the anniversary of the publication. That would be the 6th of October 2019, and then the annual fee due thereafter on subsequent anniversaries.
Yes.
Oblige, Your Honor.
Yes. Thank you very much. Well, Mr. Lumore, you have heard that, and we will now receive your submissions. Or you could take the route that Mr. Jamadar suggested, Justice Jamadar suggested.
Yeah, my lords, Your Honor, I just wanted to, before I make the submission, to refer to the facts on which the application was made, which got us here. The first one will be the first affidavit of Mr. Ernesto Torres, who is the Chief Executive Officer of Speednet.
Yes.
Which is on page
153.
yeah, which is on page 153. No, 153 is the second affidavit, is the first affidavit of Mr. Torres, which is on page 92. Your Honor, I would kindly take the court to page 99 of the affidavit, in which on that page there is also the application for stay of the decision of the PUC, page 99. If the court looks at paragraph 25 on that page, Mr. Torres states in paragraph 25 of his affidavit that by further letter dated 8th March 2017, the PUC responded to my letter of 3rd March 2017 to indicate, among other things, that it is expected Speednet to either discontinue the use of the relevant radio frequency spectrum or alternatively continue its use and make the legally required payments detailed in its letter of 21st February 2017. Mr. Torres also said, I responded to the PUC by letter dated 9th March 2017 to inform the PUC that it was acknowledged that the PUC had not revoked the decision to demand the fees from Speednet, and that it appeared that the PUC would not take the necessary steps to regularize the situation going forward. In the circumstances, Speednet was left with no alternative but to apply to the Supreme Court for relief. Then Mr. Torres came to stay of decision. In paragraph 27, Speednet seeks an order staying the decision of the PUC pending the hearing and determination of the substantive claim, if permission is granted. It does so on the basis that the PUC has waited almost 6 years to collect the sum it alleges is owed, and there is therefore no urgency to the said collection. In paragraph 28, Mr. Torres said, further Speednet maintains that the PUC is only now seeking to collect these funds in light of the CCJ's decision in favor of Speednet. The important two paragraphs are on next page, page 100, in paragraph 29 and 30. Paragraph 29, the PUC has said that Speednet should discontinue using the radio frequency spectrum or pay the amount demanded by the PUC. However, if Speednet discontinue using the radio frequency spectrum, it will be unable to deliver mobile telecommunication services to all its 25,000 mobile data customers. Speednet's mobile data business as the second mobile telecommunication service provider in Belize would have to cease immediately. Speednet is duly licensed by the PUC to provide the services that it provides to the public. And in paragraph 30, Speednet will suffer serious financial, reputational, and other harm if it was forced to discontinue using the radio frequency spectrum. Those are the facts on which Speednet asked the Supreme Court, and the Supreme Court granted the permanent injunction restraining the PUC from collecting the radio frequency license fees. Your Honor, I also would like the court to take a look at page 226, page 226, which is the written submissions of Speednet in the Court of Appeal. In paragraph 26, Speednet submits that to date, the PUC has neither granted Speednet a license to use the 700 megahertz frequency, nor has it refused to grant Speednet a license. The fact is that Speednet has been using the said frequencies pursuant to the letter, pursuant to PUC letter of 29 July 2013. On any reckoning, the letter cannot be regarded as lawfully issued pursuant to Regulation 7. That is the context in which this action was brought, and those are the facts on which Speednet relied and refused to pay the license fees, saying basically that what we call the license authorization dated 29 July 2013 is not a license. So therefore, they ought not to pay. And as they stated, they have been operating on that license till today. So when PUC decided...
Mr. Lomo, may I just ask you one question as we are at this point?
Yes.
As a question of fact, is it the PUC's position that a license was granted to Speednet in July 2013?
Exactly, a license was granted to...
Fair enough, fair enough. Yeah. Where can we find the terms of that license that comply with the law?
It will be in the same license, the letter of 29 July 2013.
So the letter of July 2013 contains all the terms of the license that the PUC granted.
Correct, Your Honor.
And that complies with the law.
Exactly.
Mm-hmm. So all of the other provisions in the Act that set out what a license should contain are irrelevant to this license.
The only thing that I noticed which is not there, but which the law sets out, is that a license should not last more than 15 years.
So therefore, on your case,
yes,
on the 13th of July, your client granted a 15-year license to Speednet.
Yes. And should pay the fees.
And when did you say by that letter those fees should start being paid?
On the publication of an amended spectrum allocation plan.
And that was done when?
In 2018, but in 2017, the PUC has written to Speednet saying that on reflection, the position they took to amend the spectrum allocation plan was misconceived. So therefore, they are asking Speednet to pay immediately.
As of 2017 then?
Yeah, because when they say pay immediately, it means you're going to pay the arrears up to 2017.
Was that a unilateral decision, or was that after consultation and discussion? Because you had represented one thing in 2013, which you just agreed to.
Yes.
And then you say in 2017, the PUC had a change of heart. Did you go back and have a discussion? This is a public authority dealing with a private entity. Did you, in good faith, go back and say, we made a mistake, what we did was unlawful or illegal, we had no power or authority? Where is that?
I cannot say as an officer that there was a meeting or consultation between Speednet and PUC to discuss the matter. But what I know is that...
Wait, pause. Let's go a little slowly.
Yes.
Before 2017, yes, is it correct that Speednet was writing, asking for the execution and formalization of this license?
They were asking for the license.
And were they saying that that was necessary for them to be, properly regularized and for affairs to run appropriately and so? Is that a tenor of that? Were they sort of complaining about the delay? Would you say that is a tenor?
Yes, Speednet was complaining about the delay.
Yeah.
And the license acknowledged that fact.
Yeah.
Yes.
So what do you think PUC should have done in 2017 when it realized its error? Well, given the representation in writing before.
They have written maybe what they should have done in addition is to sit down with them and explain to them why the erroneous undertaking they previously get cannot stand. But
and in good faith between contracting parties,
yes,
it may be that the parties would have come together and found a reasonable way forward. Yes?
Yes.
But instead, a demand was made for a set-off following a judgment.
Well, Your
The
Honor,
letter that the 2017, is it not correct as a question of fact that the 2017 letter that made the retroactive demand followed upon a judgment against the PUC, and that letter included a set-off proposal?
Yes, the PUC was under an obligation to satisfy the order made against it by the CCJ. And it is just lawful that if you owe me and I'm going to pay you, I will make a set-off.
Fair enough, I understand that, but what I'm saying is the context of the letter was the judgment and the set-off. It was not, was it, Mr. Lumore, that the PUC's board decided, wait, we need to regularize this. Let's call in or let's discuss this. So we are here today, it would appear to me, I say respectfully, because maybe what should have been done and was undertaken to have been done was never done by the PUC despite requests. And it is only when the PUC had to pay money to a provider that the PUC made this demand. Is that not accurate on the facts?
My Lord, can I take a little detour instead of dealing with your question head on, take a detour to make the point that the license was given in 2013. And in 2015, Speednet tells the PUC that they relied on the license in order to sign a contract for the 4G. So what was outstanding and demanded was in 2017, almost 4 years after the license was granted. The license was granted, only the license fees were not being collected. 4 years after, PUC said, no, we can't waive the fees, we need to collect the fees. So they decided to do that set off.
When were the fees for the license determined?
Yes.
When were they? When were they determined? When was a decision taken that this is the fee that must be paid?
It's in the what we call the license, which is the letter
of 2013.
Yes.
I see.
Yeah.
But Mr. Lumore, if you could comment, Mr. Courtney made an observation that we shouldn't regard the 2013 letter, 29th of July, I think it is, letter as a license, because he says that a license has to answer to section 13 of the BTA.
Yeah.
He said that the PUC, if it's a license has to ensure that A, B, C, and the four things are set out in section 13. Yeah. Could you comment on that? Because is it right that if indeed it were a license, that the PUC should have done these things, and did it do these things? Or does not doing these things affect the legality of the license, as Mr. Courtney suggested?
Yes. Your Honor, the letter that is in issue is on page 127. And as I indicated to the first instant judge, Justice Arana, as she done was, that it is ultimately the duty of the court to construe and interpret this letter of 29 July 2013 and make the final determination whether it is a license issued properly in accordance
but
with...
Mr. Lumor,
Yes.
I agree with, I read your submissions before the court, the Supreme Court in
Yes.
Belize, and I understand what you're saying, but my question is, and this is what Mr. Courtney, in response, I think, to a question which I raised with him, he drew our attention, the court's attention, to section 13.
Yes.
And he said that this affects the quality of the licensed, if one could use that word, of what was given on the 29th.
Yes.
He said that because the PUC did not ensure that adequate publicity was given and so on,
yes.
that is evidence, that is statutory evidence to show that what was given on the 29th was not, in fact, a license, if I understand the submissions correctly.
To answer your question respectfully, Speednet was required and in fact did publish the application, specifically stating the frequency bands they are asking or requesting from the PUC. They fulfill that condition, and it is stated in the formal application that they completed, which starts from page 112.
I don't know if I didn't explain what my problem is,
yes.
Which was created by Mr. Courtney.
Yes.
Mr. Courtney pointed to certain things,
yes,
relating to transparency, which the PUC shall ensure. That is at section 13 of the Act.
yes.
And I think that his submission, as I understand it, is that these things weren't done, and these things go to the substance of the licensedness, if one could call it that, of the thing which was given on the 29th of July.
I will say, I don't know why he made that submission, because those are procedural requirements for the license to be issued, and they were complied with. So it was not an issue at any time in the first instance or on the appellate court. It was never brought up because it was both sides assumed that all those things were complied with. The only issue in dispute was whether that letter of 2013 assigning those things is a provisional license or a substantive license. That is all was the dispute between the parties. As to whether there was compliance with the procedure through, the procedure the PUC should follow before issuing the license was never an issue, because the PUC complied with it.
But because it wasn't an issue, Mr. Lomar, doesn't detract from the fact that if it goes to the definition, if it is part of the definition of what license is, then it has to be shown that these things were complied with if it is to be a license.
Your Honor, if it was an issue, we would have provided documentation from the records of the PUC to show that those things have been done.
Okay, so what you're suggesting is that the fact that Mr. Courtney raised it is purely academic, that everyone assumed that it was not an issue
first instance or on appeal. Otherwise, the documents are there. We would have provided to satisfy the court that all those requirements were complied with.
So, Mr. Limor, I just want to be very, very clear. You are saying that the letter of July 2013 complied with the requirements for publication advertisement, etc. of Section 13. That's published somewhere on the PUC webpage.
Yes.
Oh, all right, good, fair enough. So the only term, just to be very clear, the only term that was not contained that you say was necessary to create a license was the length. In other words, this letter does not say whether it's for 1 year, 6 months, or whatever.
Yes.
This is a license that has no term. It's for an unlimited term. Is that right?
Unlimited term, but the statute says no license can extend more than 15 years.
So therefore, it is to be presumed to be for 15 years.
For 15 years, yes.
So you would say that even though it was not stated, it is not necessary because it is presumed to be for 15 years.
Exactly.
And therefore, it meets all other statutory requirements for a license.
All statutory requirements have been met.
So that even though the SAP at the time in July 2013 said that 700 megahertz was for broadcasting.
Yes.
Correct?
Yes.
This license lawfully granted this letter lawfully granted a license for mobile cellular.
Yes.
And that was permitted under the law.
It's permitted. It is
even though the SAP said that bandwidth was for broadcasting. That was not a problem. You could do anything and give anybody anything, no matter what the spectrum plan says.
There is the provision in the law that the PUC can reassign those bands. There is nothing in the statute which prohibits the PUC from doing it.
Right.
Okay, and Mr. Luma, so it was because the license says more than that. If it is a license, yes, it says that the fees are to be paid upon the publication of the amended SAP, correct?
That's right.
Yes. So that was one of the conditions. So you only pay once the SAP has been amended and it has been published.
That's right.
And it was amended in 2018. Now you say, well, the Commission really reversed that decision. First of all, was it legal for the Commission to decide that the fee had to be paid much later? Was that legal? Because the letter, and that is what you call the license, says you pay when the SAP has been amended at a later time, correct? Mr. Lumar?
Seems to have frozen.
Oh my.
I don't think my question is that terrifying.
No, I think there's a problem with his internet. Can someone in Belize call him on the cell?
We'll do so, Your Honor.
Yes, thank you.
Your Honor, he's now in the room.
He should be admitted.
Okay. Is he back with us? Madam Deputy Registrar, do you see him? Oh, yes, there he is. Yes, Mr. Lumor, you back with us?
Yes, I'm back with a call.
Okay, I'm not sure if you heard my question.
I heard.
Okay, so the question is, was it legal for the PUC, the Commission, to put as a condition that the fees had to be paid only later when the SAP would have been amended. That is part of the license as you see it. Was that legal?
It is not legal.
It is not legal.
It conflicts with section 15.
Yes.
Subsection 3 and 5.
Okay. And then nevertheless, if it was reversed, that only happened in that letter of February 2017, correct?
That's right.
And in that letter, the Commission is saying oops, we made a mistake. You should have paid starting in 2013.
Yes.
Because when I see the amount, that clearly is an amount which would start in 2013. Yes. So, but I think you said no. As of that moment, when the Commission reversed it, that was in February 2017. As of that moment, the fees should have been paid. But you're going back further. You're going back to 2013.
Yes.
And it doesn't give. When you read the letter, it doesn't give any reason. It just says, well, you should have paid this amount of money. It does not identify any reasoning, not any apology, we made a mistake, etc., etc. And I don't think there is any correspondence, I haven't seen it, where this was discussed with Speednet. Is that correct?
As far as the figures are concerned, a spreadsheet was attached to the letter.
Yes,
which
that's
is on page 185.
Yes, but that is the first time that the Commission told Speednet, oh, you should have paid as of 2013.
Yes.
Correct. Okay.
Whether on apology.
Well, if you reverse a decision, that is quite a thing to do. Now, nobody says that the Commission, as for example, the government, cannot change policies, cannot change a position, but clearly that cannot be done just like that. I take it that you would also agree that the rule of law is also a requirement that needs to be applied by a corporate body.
Yes.
Okay. Now, for example, Justice Jamada wrote in a recent case, Belize International Services, in paragraph 371, it was a lengthy judgment, the precepts of the doctrine of the rule of law mandate that governments, read corporate bodies, seeking to alter contractual arrangement, but that could also be the conditions of a license, with third-party private entities, are constitutionally bound at all times to do so in good faith, fairly, justly, reasonably, and in keeping with the standards of good governance. Are you saying that this change of mind in February 2017 is a nice example of how a good governing corporate body should act?
Absolutely. I would not say that that is a nice example of it. Your Honor will see on page 184 that the letter was copied to me. Mm-hmm. That one of the few occasions when I get a letter from the like that from the PUC. But what became clear when this happened is that one of the things that PUC could have done in those circumstances is to see whether an arrangement can be put in place so that the one-time payment that they're asking Speednet to make based upon the erroneous condition PUC put in there will not become too burdensome. But unfortunately, the whole problem is that the PUC cannot waive any license fee that are due. So though it is not a very nice way of a public authority reversing itself, PUC's hands in these circumstances have been tied by the law or by the statute.
But
Yeah,
Mr. Lumon, just clarify something for me, please.
Yes.
The letter spoke about a test, a period of testing, correct?
Yes.
So the license was a license to test?
No.
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 No. So, all right.
Speednet asked for it. PUC did not respond.
No, no. The letter of July 2013. Was that a letter to operate or to test?
No, that was a full license granted, and then without any reference to the request for testing.
I see.
Yeah.
Well, it is clear that if the law prescribes that a corporate body needs to see to it that fees are being paid, that is one thing.
Yes.
But there's also proper behavior as a government body, as a corporate body. How can you expect a company to plan business activities if they get a letter, even a formal letter, as you say, containing a license which gives clear conditions? You only pay then, and then 4 or 5 years later, that same government says, "Oh, I made a mistake. You have to pay," going back to the beginning. That is not good governance, I would think. And then the question is, okay, well, how does that balance against the obligation for the PUC to get the fees? On the other hand, they also have to treat properly with citizens and companies under the law. That I think that is also part of the rule of law and governmental appropriateness. Isn't that so?
Your Honor, I think we lost Mr. Lamora again.
Yes, it seems so.
I hope my questions are not too forceful.
We will just hang in there in the hope that he soon comes back. Yes, he's in the room. Yes, Mr. Lumon.
Your Honor, my apologies. I think somebody walked and then knocked off our connection, and the power was totally disconnected to the computer. My apologies.
Yes.
My Lord, to answer the question, there is a balancing act here. But before I deal with the balancing act, I am going to concede that the proper corporate responsibility of a public authority in these circumstances is to sit down, maybe explain to Speednet that we made a mistake. But a solution to this problem is to maybe make some arrangement for you to pay the license fees or the arrears of the license fee instrumentally over a period of time. But the law does not allow me to waive fees or delay payment of fees. But the balancing act to do is that Speednet made profits in the millions, pay no license fees, and use that money to do business. So in looking at this issue, I'll just ask the court to look at it in that context, that it is not all negative for Speednet. There are some positive aspects of the fees that they have not paid over a period of 7 years.
We have evidence that they made millions of dollars in profit, Mr. Lumore?
Yes.
Where is the evidence of that?
Mr. Courtney admitted that in the Court of Appeal in the transcript.
Okay, all
yes.
right. You can send us the reference, yeah.
Sure, yes.
Mr. Lumore, let me just clarify two matters that came up earlier, two small matters. One was the point that Justice Burgess made on Section 13.
Yes.
And I hear you to be saying to Justice Jamada that from the bar table, that
yes.
those matters were complied with, but I hear you saying also and I just wanted to confirm that you have said that matter was not an issue in the Supreme Court or the Court of Appeal?
That's right. They were never issued.
Yes.
Otherwise, we would have provided evidence.
Sorry, tell me that again.
We would have provided all the documentation to satisfy the court on those points.
Yes, I wanted to go back, thank you. I wanted to go back to the Court of Appeal judgment at paragraph 31, where the Court of Appeal said just at the very last sentence of 31, the Court of Appeal made the point on a consideration of the statutory framework in its entirety. I agree with the appellant that the PUC is not required by any of its statutes to amend the SAP before a frequent spectrum can be assigned. Is that something that you have agreed with?
Yes, we agree with that.
Okay, and how does it affect, is it significant for your argument or for the case, Mr. Lumore?
It is, I don't think that it is all that important, except it is in respect of the undertaking or the condition that was imposed in the license, that we would have to amend the spectrum allocation plan before we ask you to pay. Later on, we said that was a misconception. It was erroneous. It was wrong. So PUC reversed course and demanded payment. And that is the relevance of that particular issue.
Thank you, Mr. Lumore.
Yes.
Can you explain, Mr. Lumore, why it was not known, why the Court of Appeal was not told about the amended SAP in 2018?
Yes. Your Honor, the PUC has an in-house counsel. And when I'm retained to do litigation, then they tell me things relevant to the case. I was not aware of the publication of this thing in the Gazette until my learned friend, Mr. Courtney, brought it to my attention.
Now, I suppose when you noticed this, you must have spoken with them.
Yes.
Because it is not clear to me why did not, once they had amended the SAP, you would have thought that the commission would have told Speednet right away and say, well, we think you should pay as of 2013, but certainly now you have to pay. So let's start sending in the fees. But that was not done, apparently.
Yes, the amendment is an important regulatory document, and I'll be surprised if they kept it away from Speednet. But certainly a letter to that effect as a basis, another basis for a demand of the fees would have been very, very appropriate.
Yes. Okay, thank you.
Mr. Lumo, has the public been made aware? And if so, when would they have been made aware that this license, as you call it, in 2013 was issued to Speednet?
What I know is that there was a publication or notification to the public that Speednet has applied for those spectrum bands. And then the public was given an opportunity to send in objections to the PUC.
Right.
That's the application.
That is the application.
But the license,
and
the president
the license is to be recorded in the license register of PUC, which any member of the public can inspect at any time, which is also there.
So as of 2013, this license was recorded in the public register, you're saying?
In the public register of the PUC.
The
which
letter
a
of
member of the public, by the law of the PUC, can go and do an inspection.
And they would find the letter of 2013?
Yes.
So your case is that a license was issued in July 2013.
Yes.
And even though in the body of the letter that contains the license or that embodies the license, there is an intimation, an instruction that you don't need to pay.
Yes.
Until a certain event has occurred.
That's right.
That nevertheless, Speednet always had an obligation to pay.
Yes.
And that in 2017, the Public Utilities Commission, for the first time, indicated to them that you must discharge this obligation.
That's right. That is correct.
Do you have any further submissions, Mr. Lumo?
No, my lord, Your Honor, those are my submissions. I'm ready, available to answer any further questions from the court.
Yes.
Yeah.
Yes. Mr. Courtney, do you have any submissions in response?
Most grateful, Your Honor. Your Honor, could I start with what I call a section 13 point? And can I invite the court to look at page 534 of the record?
Yes.
If I understood my learned friend's submission and his answer to the questions, it is that the commission has complied with section 13. He went on to submit a short while ago, as I understood him, to say that there is a register held by the commission, and in that register, this letter would appear, thereby satisfying the obligations of section 13 of the Act. With respect, I submit the following. The PUC shall ensure that A, adequate publicity is given to any terms and conditions of every license issued under this Act. B, a register of all licenses granted, including any modifications of license conditions, are made available to the public, save and except where the requirements of public policy or confidentiality otherwise require non-disclosure. Those are two separate obligations imposed on the PUC. Complying with B assuming that what my learned friend says is correct, that there is this register and that there is this letter in there.
But there is no evidence of that in this file, is there? Is there?
There is no evidence of that, Your Honor, and my learned friend is correct in saying that we did not bring to the courts below Section 13. Section 13 arose in our preparation for this appeal. My point is very simple on this. I focused my submission on 13A for this court, and I respectfully submit that if my learned friend is saying that the Commission has given adequate publicity to the terms and conditions of every license under this Act, I would invite this court to have my learned friend present that to this court in the same way the 2018 amendment was not put before the Court of Appeal. I have now raised this and I would like it to be presented to the court. Where has this publicity been given to the 2013 letter? I go one step further. Section 13A says the terms and conditions. Mr. Justice Jamadar asked about the terms and conditions, and I will invite this court to have my learned friend present to the court the publication of the terms and conditions of Section 13A. Your Honor, that is my first point. Your Honors, can I just ask you to make a note with respect to the amendment to the spectrum allocation plan? In our written submissions, page 471 of the record, we set out at footnote 13 the references in the transcript where that issue arose before the Court of Appeal. In short, in my learned friend submission at the very end, he said to the court that there has been an amendment. In my reply submission, I indicated to the court that that was absolutely untrue, not knowing then that there was an amendment. And we have cited at page 415, 6, and 425, where the court comes back to my learned friend and specifically says to him, was there the publication or not? And my learned friend, I will leave it to the court to read. There was no disclosure to the court that it was in fact amended. Well, I don't need to touch on the point about the millions that my learned friend referred to. Your Honors, my next point is, the letter of the 29th July 2013, I'm now responding to the question of testing. The court inquired whether that was not the permission to test. My learned friend says, no, it was a full license. Your Honors, with respect, all I would say is the following. There is a sequence of events. There is a letter dated the 6th of May 2013, in which Speednet asks what is happening. And I will just say to the court, when you come to read again the letter of 29th July 2013, the second paragraph reads, it's on page 127. Please be advised that the Public Utilities Commission hereby grants frequency authorization to Speednet for the use of the following frequencies. The granting of authorization to use the bands is provisional at this time so as not to unduly delay the deployment of your services. This is not saying, here is your license, proceed. It is saying not to unduly delay your services. Where does that come from? That did not arise in the application filed in 2011. That was a letter that was written on the 6th of May 2013 by Speednet complaining that you are prejudicing the rollout of R4G by not making the amendment. So, with respect, the response in this paragraph, not to delay the deployment of your intended services, is a response to the complaint by Speednet. Your Honors, my learned friend in answer to the court said that the law does not prohibit the Commission from assigning the banks without a reassignment. But I invite the court to look at section 12 of the Act, to be found at page 532. Is court there?
Yes.
Yes.
532, Your Honors. Section 12, the PUC shall be vested with the control, planning, administration, management, and licensing of the radio frequency spectrum. And then it goes on to say in controlling, etc., the PUC shall comply with the applicable standards and the requirements of the International Telecoms Union as agreed to or adopted by Belize. Overleaf 3. The PUC may from time to time prepare a spectrum allocation plan with respect to any part of the frequency spectrum. A frequency spectrum plan shall, and then it sets out what the objectives of this frequency spectrum plan. Subsection 5. In preparing a spectrum plan pursuant to this section, the PUC shall take into account existing uses of the radio frequency spectrum and any frequency band plans in existence or in the course of preparation. 6. The PUC shall give notice in the Gazette of its intention to prepare a plan, and in such notice invite interested parties to submit their written representations to the PUC within such period as may be specified. That was done. 7. After due consideration of any representations received pursuant to the notice referred to in subsection 6 of this section, the PUC shall adopt the frequency band plan in question with or without amendment and cause such plan to be published in the Gazette. 8. The frequency allocation plan shall be available to the public at a prescribed fee. With respect, Your Honors, my submission is the following. Section 12 imposes on the Public Utilities Commission to prepare a spectrum allocation plan. You cannot manage, plan, administer, license the use of the spectrum without such a plan. And in fact, Your Honors, the letters, 2 letters from the PUC to Speednet is that we cannot license you because we need first to do the reassigning. They proceeded, Your Honors, in compliance with Section 12 to do the reassigning by publishing in the Gazette the intended reassigning and then publishing the actual new plan with effect from the 6th of October 2018. It is our respectful submission. This court has held in Speednet number 1 that the management of spectrum must be done transparently, effectively, and efficiently by the PUC. That is the dictum of this court. And with respect, Your Honors, that cannot be done by a private letter assigning the use of 700 frequency spectrum for mobile services, which is assigned to broadcasting. Finally, Your Honors, Section 15.3. In answer to the court's question, my learned friend said that the letter of the 29th of July 2013 contains all the terms and conditions that are required of a license, except, he said, the duration of the license. Section 15.3, Your Honors, is very clear. It is mandatory, it's at page 535. A license shall confer on the licensee the privileges and subject him to the obligations provided in this act or specified in the license. The letter of the 29th July 2013 does neither of those things. Neither of them. And Your Honors, we set out in our submissions, in our written case, at paragraph 48. So 48 to 71, our textual analysis and our legal analysis, submitting to the court why the letter did not comply with the terms and conditions required of a license. And Your Honors, we cannot trivialize what is happening here. This is not a corner shop, or as we would say in Belize, a panada shop. This is a regulated industry and a regulated entity, which is obliged by law to conduct itself according to law as mandated by law and the regulator. And I wish to submit, Your Honors, with respect, that it is very difficult to understand how it is that a regulator can say to a licensee, I am approving this provisionally for you so as not to unduly delay your deployment of your 4G services. And when I publish the amended spectrum plan, which I have already said is a condition for me to grant you the spectrum that you want, then I will formalize the situation and license fees will then be due. Your Honors, that is the law and that is the fact. We have pleaded that the Commission, for an improper motive to render nugatory the CCJ judgment, decided to attempt this set-off. There has been absolutely no denial that that was the motive, no denial. We say, Your Honors, we have made good the bad motive point. We say, Your Honors, that the letter of the 29th July 2013 was not a license and was not transparent, not an efficient and effective management of the spectrum plan. We will respectfully ask this court to grant the relief which we seek in our notice of appeal and to ask this court to declare that the PUC is not entitled, relying on that letter, to claim license fees. Now that the plan has been amended in October 2018, it is open to the Commission to do what it ought to have done a long time ago. Those would be my submissions in reply, Your Honors, unless I can be of any further assistance.
Okay, thank you, Mr. Courtney. I would say this, naturally we will consider all the submissions that have been presented and we will write a judgment. Normally, we try to write judgments within 3 months, or sometimes we go a little bit over, but within certainly 6 months at the outside. Clearly, I think I could say this without prejudice to whatever we're going to say in the judgment. What was done here is no credit to the PUC. On the one hand, there is that circumstance. On the other hand, Speednet has been permitted to exploit an asset for a number of years in a profitable manner. Now, one side wants us to say that Speednet should be allowed to continue to do this until the PUC puts this house in order, which could be a period of any time, but at least between 2013 and now, Speednet should be permitted to enjoy the use of that asset. And the PUC says that, well, in 2017, we sent you a letter saying that you should be paying this amount from 2013, which, no matter how you look at it, is very unfair, I suppose, to suddenly wake up and to say, well, look, all along you should have had this. This is now a 4-year debt you have. Mr. Lumo says, well, you could ask for time. That wasn't said in the letter, but he's saying that now. The point I'm getting at is that this case boils down to a case, quite apart from the regulatory inefficiencies, as between the parties, it boils down to a case of money. How much money, if any, should the PUC get from Speednet? And depending on what judgment we give, it could be zilch, or it could be $366,000, is it, from 2013. Maybe the parties should talk or have someone help them to talk. We will proceed to write our judgment, but we would be very happy if before we publish that judgment, you were to come to us and to say, listen, whatever you're going to publish, don't publish it. We would like you instead to enter this consent judgment. So that is something I throw out for your consideration. It is not an order for you to do so. As I said, we are going ahead with our work, but certainly I speak on behalf of the bench. We would welcome the notion that you have gotten together and seen how you can compromise this matter. So the judgment is reserved, and if we don't hear from you, we will certainly let you know when we would give it. Madam Deputy Registrar, can you bring the proceedings to an end?
Thank you very much, Honorable President Saunders. Thank you very much, Honorable Judges. Thank you, Council. Thank you, staff of the Caribbean Court of